Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. See, I call you Jireh. Lord, my provider. I call you Eunice. You are my banner.
And you are live with us on BWTV and, of course, BWF Solicitors, Facebook and YouTube. It is Saturday afternoon, the very lovely sunny Saturday afternoon here in London. And we're coming your way with another edition of the Community and the Law. My name is Oreku Sifrimport, and tonight and this evening, this afternoon, wherever you find yourself, I am at the premises of BWF Solicitors, and we're going to have another rollicking good edition of a program. Why does a skilled worker visa application get refused, and how can a refusal be prevented? If you were on the show last week, you remember we had a very practical experience of how to set up something for domiciliary care, and also to look at the care worker route. We looked at the English language, we looked at the other things. But when you put in the application, it is possible it will be refused. What did you do wrong? What do you do to prevent that mistake? We are going to delve into that this afternoon. And I have a very wonderful question for you to test your knowledge on, and that will be at the tail end of the program. Once again, my name is Oreku Frimpon. I'm coming your way, courtesy BWF Solicitors. Ladies and gentlemen, brothers and sisters, aunties and uncles, everybody, it's the Community and the Law.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
And you are welcome to the community and the law. Good afternoon to you wherever you are. Good morning to you if you find yourself at a place where it is morning. And hello to all of you. It's the community and the law live on BWTV. We're also live on Facebook on BWF Solicitors Facebook page, on YouTube at BWF Solicitors and BWTV, both Facebook, YouTube, and all the social media platforms. Once again, my name is Uriku Frimpon. I had the privilege of looking at how to set up a domiciliary care company last week on our program. And this afternoon, I'm coming with a follow-up as to what happens when you put in the application. It is very possible that if you don't do it right, then you will be refused. When such an application is refused, what happens? How do you prevent that from happening? We're going to look at that, and we're coming your way courtesy BWF Solicitors. BWF Solicitors are situated on the fourth floor of the Anna House, Seven Sisters, 214 to 218, Tottenham High Road, London N15 4NP. You can call them on 0208 493 7340. Now, when it comes to anything and everything about the law here in the UK, BWF Solicitors are our trusted partners. When it comes to immigration issues, nationality issues, family law, and all the other bits in the law, we trust BWF Solicitors to deal with the situation for us. BWF Solicitors can accompany you to go to court and launch all your appeals for you. So trust them, be with them, call them Monday to Friday between 9:30 in the morning and 6 o'clock in the evening. If you want to go see them during the weekends, it's by appointment only. The numbers are 0208 493 7340. I say it again, 0208 493 7340, or the emergency number 077 127 61884, 077 127 61884. BWF Solicitors is your trusted partner. Be with them. And by that courtesy, this afternoon, we're looking at why does a skilled worker visa application get refused and how can a refusal be prevented. Our guest will be our friend and our brother, lawyer Charles Asma, who is going to unpick all these things, what the mistakes probably people are making are, and what lawyers will be on standby to help you prevent such mistakes being made. And then you launch that, and what the result will satisfy you and you'll be pleased about that. So if you are ready, let's sit back and enjoy the program. And I want to say thank you to BWF Solicitors. We have a message for them. One other thing they do that I want to emphasize on is the preparation of wills and probates. That's a bespoke service I would want you to pay attention to and go to them for one. BWF Solicitors, fourth floor of the Honor House, 214 to 218 Tottenham High Road. I say the number again, 0208 493 7340. And also, I just want to remind you that the 10th, 11th, and the 12th of November 2023, there's going to be a very wonderful event, an investment event, a housing event, and a property event here in London, brought to you by On Point Property. And at the program, there will be a symposium, there will be speeches and lectures, there will be exhibition of properties, in Ghana, how you can get into the property situation in Ghana, how you can invest very well in the property world in Ghana, and also to look at some of the legal bits that you have to take and pay attention to. BWF Solicitors will be delivering that for you. Remember, it's happening here in London at the Pestana Lodge or Pestana Hotel, so to speak, at Battersea, opposite the Battersea Park, the 11th and the 12th of November 2023. And I said BWF Solicitors will be there to deliver the legal lecture to help you get into the property situation back in Ghana. We're taking these messages, and when we come back, we'll look at our nugget and other announcements before we get to our discussion. It's the community and the law.
Ready for the ultimate property and lifestyle experience? Get ready for the Ghana Property and Lifestyle Expo 2023, coming to 2 exciting locations. Join us in London on the 11th and 12th of November, where leading reputable real estate developers will be waiting to meet you face to face. Be inspired by industry experts as they provide thought-provoking panel discussions and live Q&A sessions. And finally, mark your calendars for the 16th and 17th of December when the expo lands in Accra, Ghana. Experience the vibrant lifestyle and rich culture of Ghana while exploring investment opportunities in the thriving real estate market. Our expo will also feature exhibitors ranging from banking and legal services to estate and property management. Get all the support and information you need under one roof. So whether you're looking to invest, visit or simply explore the world of real estate, the Ghana Property and Lifestyle Expo 2023 is the place to be. Don't miss out on this incredible opportunity. Book your tickets now via Eventbrite for the Ghana Property and Lifestyle Expo 2023. Dream it, live it. You don't want to miss out.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Welcome back to the program, and I want to say thank you to all of you that have been on. If you join us live, I want you to do a few things to make sure the algorithm looks right. Like the page, click the notification button so we put on any content, you will be notified. Then again, we also want you to share the link and put it on your platforms, any platform you belong to. Please put that link on there for us to help others to gain the knowledge we are also gaining here live on BWTV. So if you're on, share the link. Well, I want us to get as many shares and likes as possible today on the program. We're moving and soldiering on. Earlier in the week, the BWF Solicitors fraternity put out the nugget, and we was talking about dismissal of employees with less than 2 years of service. Now, last week, I think we mentioned that, or the week before, we mentioned that, and we're bringing you evidence of what it is that we're talking about. The general rule is that only employees who have been employed continuously for 2 years or more can bring a claim of unfair dismissal. However, there are some important exceptions to the so-called 2-year rule, which can be extremely helpful for individuals who might otherwise have no means of redress against their employer. These include dismissal for reasons such as family-related reasons, pregnancy, maternity leave, adoption leave, or shared parental leave. Once an automatically unfair reason for dismissal has been established, the employer will no longer be able to justify or defend their decision to dismiss in any way, as they could in a claim for ordinary unfair dismissal. So we are asking lawyers to explain to us, and later on, Charles will look at that. Last week we mentioned, and I think I asked a question to Lord Charles and to the St. George's Group directors whether they have had reason to dismiss somebody for a reason of not performing very well, or that they don't have vacancies for people to go in and fill. Now, the law says that when you have not been employed for 2 years, you could be dismissed for various reasons. Are there exceptions to that? Let's look at this nugget again. It's on your screen, and you can take a screenshot of that. If you are interested in us sending that to you, you can also text your email address or send us a WhatsApp message on 079 50422780. Then we can send this one to you for you to keep. Dismissal of employees with less than 2 years of service. The general rule is that only employees who have been employed continuously for 2 years or more can bring a claim of unfair dismissal. However, there are some important exceptions to the so-called 2-year rule, which can be extremely helpful for individuals who might otherwise have no means of redress against their ex-employer. These include dismissal for reasons such as family-related reasons, pregnancy, maternity leave, adoption leave, or shared parental leave. Once an automatically unfair reason for dismissal has been established, the employer will no longer be able to justify or defend their decision to dismiss in any way, as they could in a claim for ordinary unfair dismissal. Now, this was quoted from Employment Rights Act of 1996. Employment Rights Act of 1996, and it was a case between the Royal Mail Group Limited versus or the case between Royal Mail Group Limited and GT, UK Supreme Court Rule 5, UK Supreme Court ruling or case number 55. I think the lawyers will tell me that's how it's read out. So GT 2019 UK Supreme Court ruling on this one, and this gave us this basis for us to bring that to you. So remember, yes, if you have not been employed continuously for 2 years, you could be dismissed, but for reasons of being pregnant, going on maternity leave, adoption leave, or shared parental leave, you could say that you have been dismissed unfairly. And I don't know what the lawyers will say, what your next steps will be. We will be asking Lawyer Charles Asma that. So remember to get your questions so much ready, and we'll be looking at that later on in the program. It's a community and law, and I will keep saying that is brought to you by BWF Solicitors live on BWTV. We'll be right back.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Thank you very much, BWF Solicitors, for your kind support and continuous push for us to bring various updates to our clients, our viewers, brothers and sisters in the community. Now, this week, something very interesting came up. It was about no recourse to public funds and how you could get that removed. There's a new development that has come up, and it concerns students and their dependents. When you are coming as a student to the UK, you and your dependents are subject to no recourse to public funds. But there's a ruling that's come in this year that's so exciting. In fact, it excites me, and I want to have us look at that again. Students and their dependents can ask for the no recourse to public funds, that is the NRPF, to be removed. The Secretary of State for the Home Department, that is the SSHD, has conceded in court and drafted a new policy that students and their dependents can apply to have their non-recourse to public funds removed, and she's obliged to consider it. She added that the Secretary of State for Home Department has discretion to remove it. It looks like there's a bit of a caveat here, but I know definitely when I bring on Lawyer Charles, he will be explaining that. She has now drafted new guidance to cover these changes. Yes, I was saying, and I want to say again, that prior to this one, students and their dependents could not ask for no recourse to public funds to be removed on their status. Now, the Secretary of State for Home Departments has considered in court and drafted a new policy that students and their dependents can apply to have their no recourse to public funds removed, and she's obliged to consider it. She has added that the Secretary of State for Home Department has discretion to remove, had the discretion to remove it. That brings to mind that it might not be a compulsory thing, but they can consider that. How do you put your case forward in a way that the discretion of the Secretary of State for Home Department would use the discretion to remove it for you? The further good news is that she's now drafted new guidance to cover these changes. What are the changes? What are the guidelines saying? We'll be looking at that. And I know definitely if you've been speaking to your lawyers, you've been discussing your immigration issues, especially your students who are going for extensions, who are applying for your dependents to come join you here in the UK. There's restriction that you cannot apply for public funds. Some of the benefits that there are for people who have leave to remain or are residents or citizens of the UK. Now you can have that removed. How do you do that? Why is it that the decisions be made at this point, and what prompted that? What are some of the changes that have come in the new guidance? We'll be looking at that very shortly. Now, let's go back to our nugget. I want to retrieve that. Somebody is just text to say that, can you let us have the nugget again? Can I bring any case against my employer who I've not worked with continuously for 2 years? Yes. The general rule is that only employees who have been employed continuously for 2 years or more can bring a claim of unfair dismissal. However, there are some important exceptions to the so-called 2-year rule, which can be extremely helpful for individuals who might otherwise have no means of redress against their ex-employer. And some of the exceptions include the dismissal for reasons such as family-related reasons. Family-related reasons could be you may have been bereaved, your children needed you to be at home, your family needed you to be at home, and of course you had to break the continuity of your employment. Well, that's how I think about it. Maybe the lawyer can confirm or deny that for us. For reasons of being pregnant, maternity leave, adoption leave, or shared parental leave. These are exceptions to the rule, and you could use that to seek redress against your ex-employer. But once an automatically unfair reason for dismissal has been established, the employer will no longer be able to justify or defend their decision to dismiss in any way, as they could in a claim for ordinary unfair dismissal. We're taking another quick break. We'll be looking at the property and investment show that's coming up between the 10th and the 12th of November. We will also be telling you something about the English language that you need to write. KT Ed Consult is inviting you to come join them, and they will teach you and give you all the strategies to write the English language live in the UK and all the other bits to pass. Then again, we say, remember to get your will and probate done, and we're doing that through BWF Solicitors. We'll be right back.
Ready for the ultimate property and lifestyle experience? Get ready for the Ghana Property and Lifestyle Expo 2023, coming to 2 exciting locations. Join us in London on the 11th and 12th of November, where leading reputable real estate developers will be waiting to meet you face to face. Be inspired by industry experts as they provide thought-provoking panel discussions and live Q&A sessions. And finally, mark your calendars for the 16th and 17th of December when the expo lands in Accra, Ghana. Experience the vibrant lifestyle and rich culture of Ghana while exploring investment opportunities in the thriving real estate market. Our expo will also feature exhibitors ranging from banking and legal services to estate and property management. Get all the support and information you need under one roof. So whether you're looking to invest, visit or simply explore the world of real estate, the Ghana Property and Lifestyle Expo 2023 is the place to be. Don't miss out on this incredible opportunity. Book your tickets now via Eventbrite for the Ghana Property and Lifestyle Expo 2023. Dream it, live it. You don't want to miss out.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
And we're right back. I have another text here that's asking, did the new fees really take off on the 4th of October as was announced? Yes, I think so they did. And maybe for your benefit, I'll go through that again so it answers your question. From the 4th of October 2023, immigration fees have really increased, and the changes, as you see on the screen, have taken effect. Leave to enter for persons in the UK who are liable to immigration detention has increased from 1,048 to 1,258. Leave to remain is the same, 1,048. Certificate of sponsorship, that is skilled worker, tier 2, minister of religion, and the others have increased from 199 to 239. Indefinite leave to remain, main applicants and dependents have increased from 2,404 to 2,885. Naturalization, that is British citizenship, from 1,250 to 1,500. Nationality registration as a British citizen for children is increasing from 1,012 to 1,214. So take note of that and be informed that from the 4th of October 2024, these fees have gone up. Welcome back and thank you for joining. Yes, I have done my bit and all the rest of it, and I'm bringing you the expert to help us do that. Remember, we're doing this courtesy of BWF Solicitors, our trusted partners when it comes to the law. Why does a skilled worker visa application get refused, and what do you do so you avoid the refusal? But first of all, let me get back to the nuggets. Okay, let me do it this way. Whatever floats my boat, I'm going to do that now. I'm going to introduce my guest because I've been doing all the talking and I've gotten him ready to speak to us. Lawyer Charles Asma from BWF Solicitors. Lawyer, good afternoon.
Good afternoon, Black people.
Thank you very much for joining us. How are you doing?
Very well, thank you.
Okay, and viewers and listeners are asked that you got ready because we're going to have the explanation of the two interesting things that I did. Last week when we had our discussion, we talked about setting up a domiciliary care company or organization. Now, when it has been set up, definitely we need to recruit people to work in them. Now, we get people from outside of the UK to come in. That application looks quite straightforward. It is established that you need to pass your English language, get your application through, and your visa, if you meet the requirements, will be granted. But I know, and I've heard, and there's evidence that people have their applications refused. Why is it so? Let's once again, we'll be looking at that. But let me go to our nugget again and look at 2 years of continuous employment by any organization and say that they can dismiss the person. Can we look at that as unfair dismissal? What are the conditions? We read from there, but with your input, we can pick and understand it better. So that 2 year thing, what is it? And can any employer in his or her own right dismiss me?
Right. So we have the statutory position, and we have other exceptions or common sense approach. So the starting point is the statutory position. An employee is defined within Section 230, subsection 1 of the Employment Rights Act 1996. Now, we're also looking at if that person is an employee, can that person bring unfair dismissal claim? And the point is that you should have been an employee for at least 2 years.
Yeah.
That is within the statute.
Okay.
But if you go further through the nugget, it says that there are some important exceptions to the so-called 2-year rule. So the starting point is should have worked for the employer for 2 years to qualify to have the right not to be unfairly dismissed. Now, the point we are making is that, yes, I haven't worked for 2 years, but the rule says that it can be extremely helpful for individuals who might otherwise have no means of redress against their ex-employer. In other words, if you have been dismissed and you want to bring unfair dismissal claim, and you have not done 2 years continuous service with that employer, then you have no recourse within the rules. However, the exception is that dismissal for reasons such as family-related reasons, pregnancy, maternity leave, adoption leave, or shared parental leave. So let's take note of this. You can see that we have certain characteristics mentioned here. Is the dismissal based on family-related reason? Is the dismissal based on pregnancy, maternity leave, adoption leave, or shared parental? So you can see all these are family-related. Again, we're also saying that once the automatic unfair reason for dismissal has been established, the employer will no longer be able to justify or defend their decision to dismiss in any way. And the key thing is that they could, in other words, as they could be a claim for ordinary unfair dismissal. So the key point here is that, yes, if you haven't done 2 years with the employer, you cannot bring unfair dismissal claim. But there could be some exceptions. And your job as an employee is to ensure that you fall within those exceptions. Exception could be that if the reason for dismissal is family related, for example, you are pregnant, and because of that, we cannot have you, then you are encroaching into the exceptions. Or we're saying that, okay, we see that you are pregnant, you'll be going on maternity leave very soon, and the rules say that you may have 36 weeks. That means you're going to be away for 36 weeks. That's going to cost us money. Can we have a way to dismiss you? Then that will also fall within the exceptional rule.
Okay.
Or, for example, somebody has the right, of course, be it a father or mother, you have the right for what we call parental leave or adoption leave. If those exceptions are there, then the rule for 2 years will not go in the favor of the employer. But the key point here is that once an automatic unfair reason for dismissal has been established, the employer will no longer be able to justify or defend their decision to dismiss in any way, as there could be a claim for ordinary unfair dismissal. So, yes, the employer has a right to dismiss as long as the individual has not done 2 years and there is reason for dismissal and the individual cannot bring action in law at the employment tribunal. However, if the dismissal reason falls within the exceptions, then the employer has to be careful. So yes, 2 years. However, there could be some exceptions.
Okay. So if I don't have these reasons to depend on, then my employer can go scot-free. But if, for instance, coming to the realm of our discussion, the employer does not have enough work for me to do, and I haven't worked for 2 years, would that be a good reason for this employer to terminate my contract and say that, well, unfortunately, circumstances for your employment have changed, so I'm going to get rid of you?
Not having job for the employee is not a good reason to dismiss. So there should be a fair reason as well. And yes, and I think that is the loophole the employer will be exploring to say you haven't done 2 years, and therefore After all, if I dismiss you, you cannot bring any action because you don't have that statutory protection. However, there's contractual protection. Because if you employ me, for example, fixed term,
Okay.
let's say 2 years or 3 years,
Mm-hmm.
within the remit of my COS
Mm-hmm.
or my contract, that's a contractual obligation on you to ensure that you keep me for those 2 or 3 or whatever period.
Mm-hmm.
So even if I don't have recourse in law within the Employment Rights Act, I may have recourse in law within contract, and therefore contractual claim can be brought.
Right. Okay. So we had another one that I brought in, the no recourse to public fund thing that has been introduced that excites so many people, including myself. And it says that students and their dependents can ask for no recourse to public funds to be removed. Good news, yes.
It is good news. The beauty of the laws in the UK is that it's family sensitive and human
Mm-hmm.
sensitive. And regardless of where you come from or your background, the law seeks to protect everybody. And you can see that this is a judicial review where somebody feels that it is not fair for people who have 2.5 and they are foreigners to be given opportunity to have their no recourse condition removed. And others who are also foreigners and may have 1 year or 3 years leave do not have that right simply because they fall within different category of immigration routes. Then the law says that that again the Home Office have to look into, and you can see that this is for students. And once this becomes, once we have a situation like this, it opens a temporary floodgate for everybody who wants to chance upon this opportunity. However, you have to meet the rules. So it says that the Secretary of State for the Home, Secretary of State has conceded in court and drafted a new policy that students and their dependents can apply to have their no recourse public fund removed. And the Secretary of State is under duty or obliged to consider that. And it is added that the Secretary of State has a discretion.
Yeah, I think
That's the key word, discretion.
that is where I find it quite tricky. Yes, they have considered in court that they're going to be able to remove that, but then it becomes a discretion. So when they feel like not doing it, they will not do it.
Not that it's feel like, all no record applications, you have to meet the rules.
Mm-hmm.
So there are people who apply to have their no record condition removed, and the application is rejected because they feel that they are able to fend for themselves in terms of living.
Mm-hmm.
And therefore, if you have the means to wait, then you will not be necessary. The condition will not necessarily be removed. So it's not automatic.
Okay.
And that's why it says that yes, you can apply. However, if you don't qualify or we feel that you don't meet it, we will not remove it. It's a discretion. What it means is that it is not compulsory for them to do. So what does it mean? It means it's up to the applicant to show on a balance of probability that the removal is necessary for their survival and any child that is involved. And where there are children involved, it makes the case even stronger.
Right. So they have drafted new guidance to cover these changes. Have there been major changes, or this is the only significant one we can pay attention to?
You can see that this is a fresh case. It's a judicial review case. Normally, judicial review will go to court for court to review the decision of the Home Office.
Mm-hmm.
The decision of the Home Office was that if you're a student and you cannot survive and your condition is to be removed, it will not be removed.
Mm-hmm.
You can't access public fund because you claim that when you come, you'll be able to maintain yourself as part of your student visa application. Now you say that you don't have money and you want support from the state. So the Home Office refused the application. It goes to administrative review. Home Office maintains the decision that you don't qualify because the rules don't cover students. Then it goes to court for court to consider whether the decision of a public body is proportionate to human right. So it's a public law area of consideration.
Okay.
Public law is where the matter is unconstitutional or is incompatible with available policies and rules, and it is made by a public body, then it becomes a constitutional matter. So once it is reviewed by court will say that that decision is in contravention of other provisions of other related rules or policies. And so you can see that it's a parative matter. And the parity is that we are looking at people who are foreigners, yet qualify for their condition to be removed. And others who are foreigners but do not qualify. There seem to be level of discrimination or disproportionality of the application of the law. And I think that is where the court concluded that it would be unfair for the Secretary of State to rule out completely that they will not exercise discretion to consider favorably applications for removal of such conditions from students.
Well, as a layperson, I've always contended, and I think I've asked on this program a few times that if I'm contributing to the national pot, I pay my taxes, I pay my national insurance, and the rest of it, and you consider me not to be qualified for any public benefit, then I don't feel like you are treating me fairly. These are some of the things that I know lawyers have looked at, and things are coming. Now, lawyer, quickly on this one before we go to our main discussion. When does this kick in? Is it an immediate thing, or would have to wait until the guidelines have been really drafted, tested, and approved before we can take advantage of a situation like this?
So once the draft is set out, a new policy guidance will be put in place.
Mm-hmm.
A window will be open for such applications to be considered from those who make them. So it's up to such individuals to look out for the window and take advantage. Just as when COVID came and there was opportunity for the same no recourse condition.
Mm-hmm.
No recourse condition that has become very popular, starting during COVID, where a child, few children had their litigation friends, body take government to court, and government concedes that it is not fair for those children to suffer. Their parents cannot survive because of they are doing 2.5 hours and the job is no longer there because of COVID, and they cannot survive, they cannot access public fund because they have such condition. And it was accepted that they could make an application in the interest of the children. It is very popular now, and that's what is now going towards the favor of students. And I foresee that it will go very soon, if this continues, go in the favor of skilled workers as well.
Well, hopefully it does. And if there's any development, definitely you trust that BWF Solicitors will get us to know about that on the various legal education programs that we have. Remember, we have one on Thursday at 9 in the morning. That's live on Rainbow Radio. Then on Fridays, we have one on our platform here with Na Manyati. And then we have the community and the law on Saturday afternoon. That concludes the whole weekend bit of it. It's a community and the law, and what we're discussing this afternoon is why does a skilled worker visa application get refused, and how can a refusal be prevented? We are at the premises of BWF Solicitors. We are here, and they are helping us to unravel that. How do we prevent such from happening? It seems and sounds like a
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Thank you very much, BWF Solicitors, for your kind support. And to all of you who are live with us, we live on BWTV, BWF Solicitors Facebook, BWF Solicitors YouTube, and all the social media platforms. I've got Tilly Duma here, Nana Jimang, Dorcas, Gina Aduse, Upsound Akrobi, and Nana Bob. All of you are live with us. Sandra Fraser, thank you for doing your usual thing. Obviously, you let people in on the location, the services, and the various contact details. So leave your comments in the comment section below and help us to get to other people as well. Nana Tiohini, you're also live with us. Thank you so very much. Now, let me ask the question again. Why does a skilled worker visa application get refused?
Thank you very much. Viewers and listeners, once again, good afternoon. We have met again on the studios or in the studios of BWF Solicitors to bring you the good news. And the good news today is that we want you to understand why these days or in recent times, we hear about skilled worker applications getting refused and what we can do to remedy that. Your aim is to apply and be successful. So you want to get it right. What could be the impediment and how do we get around it? So we want to start with the underpinning policy or the rule. The rule for, or the policy that the caseworker uses for the consideration of such application is what we call appendix skilled worker to the immigration rules. And appendix skilled worker is divided into paragraphs. So SW across board. There are three key elements to skilled worker visa application. We have the main applicant, we have the dependent spouse, and dependent child. Each of these three categories or areas have specific provisions of the rules to apply. So you are applying as the main applicant. One thing that you have to consider is what we call the genuineness or genuine intention to work. The genuine intention to work. And the second thing is your immigration history, past immigration history. Very important. The genuine intention to work. Do you really intend to work for this employer to the effect that you should be granted entry clearance to enter the UK to work? Or you are seeking to enter the UK just for entering sake? That is one thing that we have to be mindful of. So what do we mean by genuine intention to work? You have applied to work for an employer in the UK, whether it's in the care sector, construction sector, or any other sector, insofar as the employer has license and to sponsor you for that role. How did you find a job? So to be able to test that there's genuine intention to work, the caseworker, or even when you arrive at the port of entry in the UK, the immigration officer can ask to or can test that intention if it is genuine enough. Where is the work or the job located? How did you find it? How did you apply for it? What experience do you have? And does that experience offer you the opportunity to be able to perform the role for which you have made this application. Again, how much do you know about the job? If you have X number of years experience on the role, then you'll be able to answer questions that may be put to you. Is the immigration officer supposed to ask you those questions pertinent to the work? You can say no, but I would say yes, because they can ask any question about your application, because they have your application before them. What it means is that if they don't ask such questions at the time of your application, they may ask them at the point of entry. So it's important that you are conversant with this and you can establish genuine intention to work. If the intention to work appears to be weak from the assessment of the caseworker or the assessment of the immigration officer at the port of entry, then either the application will be refused or you may be denied entry. Another point is that these days the employers have been asked to confirm that there's genuine intention for this person to work for them. So if the employer is asked to confirm certain things and the employer is not able to confirm them, then there will be conclusion or adverse inference that there's no genuine intention for this person to work for this employer.
Sorry, let me cut here and ask this interesting question. The genuine intention to work. Obviously, I've applied for a job. I've been given an employment contract. This employer is required by the rules and the regulations and by law to check on my background and make sure everything is in place before they give me the contract. Why would I have to go through that rigorous questioning again at the point of entry?
Prior to 17th of July 2023, such test was not part of the provisions.
Yeah.
But what the Secretary of State has concluded on is that the job that the employers are supposed to do is not being done properly. So they have taken it upon themselves to do it. What job should the employer be doing? The employer should be aware that this person coming to work is actually coming to work.
Okay.
So if the person is not coming to work, but coming for a different reason, then it will be easy for the caseworker to refuse the application. So if the employer is not up and doing because they have some interest, then the state has taken it upon itself through the immigration provisions to test that intention to be a genuine worker. Yes, the employer has done whatever they're supposed to do, but the employer may get it wrong. And therefore, the Home Office wants to make sure that this person is genuinely coming to work for the employer. At the same time, they will be working with the employer. So they will ask the employer to confirm X, Y, Z. If the employer is not able to confirm, then they will conclude that their presumption is right.
So then the onus is on the employer to make sure that everything is right. Because I have applied for a job. I have gone through the interviews and the recruitment process, and I have been offered that employment. So if the employer didn't do his or her job well, I do not have to suffer.
You are coming to work for an employer.
Yeah.
And so if the employer does not exist or does not appear to be a genuine employer, then there would not be genuine role for you.
Okay.
And therefore, your intention may not be genuine as far as that employer is concerned. Will you believe that people make applications, and by the time the application is decided, the employer has ceased to be a license holder? And if the employer has ceased to be a license holder before the application is considered, then what will happen is that the application will be refused.
Can I bring any claim against such an employer? Because I had the intention and expectation that this is what I was going to be offered. Now he or she has not done their.
So there is common law duty on the applicant to ensure that the employer is a genuine employer
Okay.
and that does genuine job. That is called careful and diligent assessment on the part of the applicant.
Right.
So if you are not diligent and careful enough, then equity will not favor you. Should the employer conclude or it is proven that the employer is not even able to offer you the job.
Okay.
So let's assume that you haven't done your job properly, and by the time your application is put in, the employer has lost the license to sponsor you,
Yeah.
and you apply. Of course, the application is already there, but from the time the application is made up to the time the application is decided, the employer has lost the license to sponsor you. The question is there a job still?
Well, once the license is lost, there's no job.
Exactly, and therefore, it is up to you, the applicant, to ensure that as part of the genuineness assessment test, you go through all that. And you can see that because of that possibility, the Secretary of State now expects the applicant to also do their job properly, so that there will be no chance for them to conclude that it appears that there's no genuine intention. That is one side. But
Okay.
even if the employer exists and the job exists, it's up to you to confirm that, yes, you have what it takes to be able to perform the role.
Okay.
I have applied, I have been interviewed. But the fact that you've applied, you've been interviewed, gone through the process successfully, offered a job, it might be that you were able to excel at the interview. Maybe that you were able to present yourself properly on your CV, but not necessarily having the competence. And therefore, if it's a case of interview and you are interviewed before your visa is decided or your visa application is decided,
Yeah.
then you can conclude that there's no genuine intention. For example, let's say you are called to attend interview and they ask you, right, where is the job located? You give them the answer. How long has this company existed? You give them some answer. That means the answer is not 100%.
But I'm not obliged to tell them that because it's the owner of the company that will have to tell you how long they have existed.
No,
I have applied because I found them to be having a vacancy, and I did.
yes. So it's a shared duty. I'm just giving an example. I'm not saying that if they ask you this and you are not able to, I'm just pointing to the fact that having a genuine intention to perform a role means that you have done your research and assessment about the role. And so, so the point here is that researching about the role includes researching about the company.
Okay.
And if you are researching about a company, you may be able to know how long the company has existed, for example. You may be able to know whether the role is what entails in terms of the job description, in terms of the specific duties, and so on and so forth. So if you are asked, what does this job entail? You're able to give them the job title, but you are not able to go into specifics. Then you don't maybe know much about the job.
Okay.
It might be the case that your intention is not for the job, but for something else. So it's about giving room for such inferences to be made. And that's what we are trying to let people be aware of, because they are testing genuine intention. And the fact that you have received your certificate of sponsorship, you have made the application, does not mean that you will succeed with the application if certain things are considered to be out or to be missing.
Okay. There are situations where somebody would have successfully had an employment contract, but the same person on a previous occasion or several previous occasions been refused a visa to enter, either as a visitor or for any other situation or category. Will that affect this sponsorship or certificate of sponsorship application to come in for a job?
So that's the second assessment. So the first assessment was about you having the genuine intention to work or to come and do what you claim you are coming to do.
Yeah.
We've gone through with examples. The second reason why application could be refused, even if you have the genuine intention, is your immigration history
Right.
and the representations that you make about them or the disclosures you make about them. They ask you several questions as part of your application. And most important one being your immigration history. Question could be or is, have you ever been refused a visa to any country at all in the world? Or have you ever been refused a visa to the UK? When they ask you any country at all, that includes UK. And when they ask you UK, it is UK. So any country at all, you have to disclose.
Right.
The answer will be yes or no. If you say yes, then they will ask you to give the details. If you say no, the presumption is that you are clean. There's nothing to disclose. Then you move on with your application. But have you ever been refused a visa before? To the UK especially, only you can tell.
Okay.
Only you can tell.
Yeah.
So if the lawyer making the application for you, or the friend making the application for you, or you making your own application cannot, if the lawyer doesn't know, the lawyer will not be, but the lawyer will take instructions from you. So it's important that that question is answered truthfully. Because if you have been refused before and you say no, that is false representation.
Okay.
What it means is that your application will be refused and you also be banned possibly under relevant provisions of Part 9 of the Immigration Rules, paragraph 9.7.2, and that will take you down to paragraph 9.8. If you are refused under 9.7.2, then it will trigger 9.8, because 9.8 says that if you have been refused under 9.72, then any future applications will be refused automatically.
Right.
And that is what we call the ban, 10-year ban. So it's important that you tell them the fact that you have been refused doesn't mean that that is the end of the world, because every application is decided on its own merit.
Okay.
You might have been refused for a visit visa. And the reason was that at the time you applied to attend an event, and the time the visa was being considered, the event was over because you delayed in making your application. So they concluded that the event is over, so what's the point going? And you were refused. So you tell them, you explain why you were refused. Or you were refused because they thought that you are not committed enough in your home country, and therefore, if you were to be given a visa to enter the UK, you will not return. So the returnability test is not met. So you are refused. Or they think that you don't have enough funds to meet the cost of your trip, and so you may be a burden on the state. And on that basis, you are refused. That's fine. You just tell them that I was refused for a visit visa application in the whatever year, and you tell where it happened, whether happened in Ghana, happened in the UK, happened wherever. So it's there. Then you give them the information. If you were banned on that application of refusal, then of course that will affect this one. But if there was no ban or paragraph 9.8 clause, then you are home and dry, because it's a matter of explaining yourself.
But if you were banned and you have finished serving the ban, for instance, you were banned for 10 years and you've stayed away from the UK for 10 years, now you found a job and been given a proper and appropriate certificate of sponsorship, would that still affect you?
Well, the default position should be that once you've served the 10 years, it should be given opportunity subsequently. But they will tell you that the ban has become a yoke, and that yoke must be removed. So you seek revocation of that order, for example, for it to be removed so that you can have a clearance. And therefore, a caseworker will conclude that even though you finished your 10 years, that decision has not been fully removed. So you have to apply for it to be removed, to be given full clearance. It's very debatable, but that is what they often do. They will require you to apply for revocation of that order of banning you for 10 years. Now, another example could be that you were refused because you applied as a student and for whatever reason you didn't meet the rules. Now, if you're applying this time as a skilled worker, you should be successful because the conditions are different. But if you are refused, for example, and as we said, for false representation or for use of false document, then that is also another thing for adverse consideration, because anything under paragraph 9.7, especially the mandatory element of point 2, will trigger 9.8. And that is what will tell viewers and listeners making application that if you are making application for the first time to the UK or British Embassy abroad to come to the UK, please be honest. Documents, even if it's going to take you a while to get the right documentation, take your time and get the right documentation because they have the power to verify. Yes, you say that you should be given the mandate to refuse warning so that you can clear yourself. Yes, but even that, if you are not granted a mandate to refuse, and you still have to go through a hurdle to clarify situations. So why don't you go clean? If it is ethics that they are asking you to confirm because you have a degree, make sure your ethics is certificate is authentic.
No,
If it is
for the ethics where you do the comparison and get them to clear that, is it something that can depend on to refuse you, or they will give you the minded situation where that if you don't get this, your application will not be put through. So go and bring
so ethics is a point threshold. That's the English proficiency.
it. Right.
So if you don't have the English proficiency, you score 0.
Okay.
And if you score 0 for English, you don't meet the threshold for skilled worker application.
Right.
Because you have to look at the job, you have to look at English language. And of course, the job salary also scores points. So having COS is not enough. Let's assume that your English language certificate is verified and it doesn't exist. You would say they should come to me to ask me to provide a new one.
Yeah.
But if they assess and it is not there, they will score you 0.
Okay.
If they score you 0 because it doesn't exist, because what you gave them has no basis, then that 0 score is warranted.
Okay.
And once you have scored 0 for English, you don't meet the threshold and the application will be refused. In this case, there will be no ban because they won't say the English certificate or whatever is not genuine. They will refuse you and say that you don't meet the threshold. What it means is that you have to reapply.
Okay.
But you have reapply this time, making sure that you have met the threshold. But if they go further to check something and they feel that the documentation is inauthentic, then what they will do is that they will, of course, they have to give you the mandate to refuse. But if they don't give you the mandate to refuse and they refuse you, it will fall under the mandatory threshold that you used false documentation. So for the main applicant, false documentation will be one factor. If you're not able to prove that you have a genuine intention to work, it's another factor. And if you are not able to disclose your previous immigration history, there will also be adverse reason or factor. So 3 factors there. Let's move to the partner.
Okay, but before then, let me just advise and tell viewers that if you have any question concerning this particular topic or any other question, you can put that in our comment section below and we'll pick one up. And you can also send it as text to 0739920848, 0739920848, or you send a WhatsApp voice note on WhatsApp or a text on WhatsApp 07950 Remember, we looking at the question, why does a skilled worker visa application get refused and how can a refusal be prevented? And we have our guest lawyer Charles Asma from BWF Solicitors helping us go through that. So if you have any questions, any concerns, bring them in here. 07399 208468 or WhatsApp 07950422780. Want to say thank you to BWF Solicitors as they have always given us one resource to share knowledge with us and also three advising us through various means, nuggets and all the other programs that we come your way with. And as I said, guest and resource person this afternoon, this evening is lawyer Charles Asma of BWF Solicitors. You can contact him directly. His details will be put on whilst we go on with the discussion. Now let's look at the partner lawyer.
Good. So we have looked at the main applicant.
Yes.
3 factors are crucial, and those 3 factors can affect your application decision adversely. They are, do you have a genuine intention? And so if you are interviewed before your visa is granted, can you pass the genuine intention to come and work test? Or if you arrive at the airport and the immigration officer interviews you, because they have the power to interview you, even if you have arrived, will you pass the genuineness to work test? Or if they go to your employer to verify further information, will the employer provide information that will conclude that you have passed the genuineness test? So genuineness test is crucial for the work. The second factor for the applicant is your history. Have you been refused before? Or have you been banned before? If you have been banned, there's no point making the application because it's going to be automatically refused. Or if you have been refused but you don't disclose it, the application will also be refused, and they will tell you that you were not truthful on your application form. Or the documents you are using are not authentic, then that will also be ground for refusal. So these are the points we have established. The next thing is for the partner. The partner, for you, you are depending on your skilled worker migrant spouse. So whether you are the husband or you are the wife, you are dependent on the other party. So it's crucial that the other party gets it right for you to have something to hang on. Now, what would be the reason for your refusal? Are you a genuine partner?
Okay.
Are you married to the person, or have you lived with the person for 2 years in terms of cohabitation if you are not married?
Okay.
If you have married, show marriage certificate. If you haven't married and you are relying on durable partnership, that's 2 years cohabitation, you have to prove 2 years cohabitation.
Okay.
That is why this time they have included that as part of your documentation that show that you have lived together for 2 years.
Okay.
What it means is that if you have been married for 2 years, they can ask you to show 2 years of living together. Genuine and subsisting relationship.
Okay.
If you are genuinely in a relationship, then you'll be able to provide certain things to show that you've been living together, what we call proof of living together, proof of common address,
Okay.
bills in your names, either in your joint names or individual names, but pointing to the same address.
Okay.
Bills will be energy bills, water bills, what have you.
Do I have to show that over a very considerable long period of time?
If you have been married for, let's say, 3 months, and you have been living together for 3 months, then you can only show for 3 months.
Okay.
But they will ask you how long, when did you start living together? If you say that we started living together 3 years ago, then they will ask you to prove 2 years at least.
Okay.
And it is you telling them what they have to ask you. So you have control
Over your
over what they can ask you to provide. Because if you tell them that based on your relationship and based on when you started living together, you have done it for a long period of time, then you have to show minimum of 2 years.
Okay.
But if you tell them that based on your marriage and when you started living together, if only you married, let's say, January, February, March, we are in October, you are making your application. What it means is that if you live together, for example, you were not living together before you married, but you started living together after your marriage, then you can show from when you married. Some people live together before they marry. And therefore, if you were living together before you married and you continue to live together, then you have pre-marriage life together. Then you have to show from there.
From there. Okay. Maybe I may come across as jumping the gun, but we're talking a partner who is dependent on the main applicant. What about children who depend on the main applicant as well?
So, as I said, there are three categories: the main applicant, the spouse, and the children who may be involved. We'll come to the children, but let's settle on the partner.
Okay.
You can also see that if the partner is refused, on the balance of probability, it is high that the spouse, if the main applicant is refused, then the partner may be refused.
Okay.
However, there are instances where the main partner, the main applicant gets refused and the partner gets granted. There is a case that someone called me about. The main applicant was refused. The partner was granted. And because of whatever reason, the partner said that, goodbye, I will see you somewhere, sometime. So the partner who has been granted came to the UK and I arrived at the airport. I told you that they know everything.
Right.
When they click, they see your application and the decision. So don't think that the immigration officers at the port of entry don't know the application. They see everything. So the person questioned, your wife has been refused. So what are you doing here? Because your application said that I'm joining my partner, who is a skilled worker migrant. Either we are going together or I am joining them, not the other way around.
Right.
So they said, what are you doing here? The person has been refused. So who are you actually coming to join? The person was detained. Could this be a legitimate detention? Can say yes.
Yeah. Because the person you're coming to is
yes. It's a condition. Your arrival is conditional. So it's a condition precedent. And the condition precedent is that you have to, your spouse should have it for you to join them.
Yeah.
Or should have it so that you come together. So if they don't have it and you have it because you are lucky, yes. If they say no, then they are right to say they can't let you enter. So the other reason for you having your application refused as a partner is if the main applicant spouse is refused.
Okay.
And again, if you're not able to prove the 2 years living together. And this, as I said, this time they ran interviews. They don't often call people to interview, but they have the power within the rules to ask for interviews or call you to interview. If they don't do it there, they do it when you arrive at the airport.
Okay. Now let's look at the
children.
Yeah.
So your children are joining you. Either the children are for both you and your spouse or for one of you. If the children are for both of you, it's cool because you don't have to show sole responsibility. And you don't have to show serious and compelling family circumstance that makes the exclusion of the child from the UK undesirable. So the same sole responsibility threshold has been transposed into this area. So as a child, you have to show in your application that your parents are in the UK and you are joining them, or your parents are migrating and you are joining them at the same time.
Okay.
If it is one parent, you have to prove that that parent has sole responsibility over your life. What shows that they have sole responsibility? Everything about sole responsibility that we've been preaching about will come in.
Okay.
The next thing is what we call consent letter. Consent letter, we have to be careful here. If you are claiming sole responsibility, consent letter can only be signed by one parent.
Okay.
If it is signed by both parents, then the presumption is that there is no sole responsibility after all. Then that child has somebody else, another parent, to care for them. So you don't necessarily have to come with them, or they don't necessarily have to join you. in the UK.
Okay.
If both parents are, if both parents are parents of that child, then you don't have to show so responsibility, because you have shared responsibility. Both of you have to sign the consent form. The next thing you have to show as a child is arrangement for accommodation and arrangement for your care. So in the consent letter, the parents or the parent must show whether there is adequate accommodation in place.
Okay.
If there's no adequate accommodation in place, then it will be difficult for the child to be successful. Again, we are looking at the care of the child. You are letting your children join you in the UK. So what care arrangement do you have or have you put in place so that when the child arrives, they will be able to receive the necessary care? If you are working, who is going to be there for the child? And that is crucial. So you have to explain how the child will be cared for once they come in or once you come with them, because you are coming to work or you are already working. If both parents are coming or one parent is coming with the children, then in terms of the care, you are able to explain that as one is working night, the other will work, or the other one is not coming to work and therefore will be available to care for a child. Or you have to show that there is adequate care in place for that child. You have to explain all that, and where possible, add evidence. So if it's a case of accommodation, you can show your tenancy agreement showing that you made Part 10 or X of the 1985 Housing Act, which tells the threshold for avoiding overcrowding, depending on the number of people living in that household. Children under 13, children over 13, and the spouses. The number of rooms, including living room, are crucial. So if you are living in one room and you have 3 children joining you, then the question is, do you have adequate accommodation for you and your partner and the children, depending on your circumstance? And it's up to the child to prove all this. Even though the child is the one proving, it is actually the parent proving it. But the application is for the child. That's why they ask them, prove that your parents have the necessary, or you have the necessary things in place for yourself when you arrive.
Well, if you just joined us, we're live on BWTV, and we have as our resource person Lawyer Charles Asma from BWF Solicitors. Why does a skilled worker visa application get refused, and how can a refusal be prevented? Text number 0739920848. WhatsApp only 07950422-780. Now, I have a question on the platform, Lawyer. Maybe we can quickly pick that one up. And it's from Nanette Ahini. It says, how can evidence of cohabitation be proven in Ghana? That you have lived together for 2 years in Ghana. If it is proven, can this be used for health and care worker visa if one of them is eligible, or for both to relocate? I think can just one person prove that they have cohabited in Ghana, or it has to be proven by both of them?
That moment when we're discussing the reason why the main applicant may be refused, or the skilled worker applicant, him or herself, may be refused, we didn't touch evidence of living, because yours is just about the job. And that is why the partner also doesn't have to prove genuine to work, because they are not coming to work for any employer. They are joining their spouse. But if you are joining your spouse, what shows that this is a genuine relationship?
Okay.
So the test is for the partner, the dependent partner, to prove. What can you use? Any country at all. We are not isolating a particular country.
Yeah.
You can prove by, I mentioned bills, utility bills. So you can use utility bills. You can use tenancy agreement. You can use mortgage document. You can use land title documentation. You can use hospital notices to you to attend appointment. You can use letters from government organizations, be it the GRA, for example, Revenue Authority. So let me just say Revenue Authority, from the tax office, from the council or the local authority or the district assembly. All these are, insofar as they are verifiable, then you can use them.
We bringing you the discussion. We're going to continue with that. Anetria here says, please, health and care worker visa, is it continuing? Has the government got any intention to end it? If yes, when? I think there's been an answer from our principal, which says that yes, the Immigration Advisory Committee has advised that it should continue. We always advise employers to be mindful that there will be compliance visit by the Home Office, so they must always get their house in order. Lawyer, this one will come to you. That has not been answered on the platform yet, so let me bring it up here. Lawyer, yes or no questions are tricky. Help with this, please. No child visa. If questions say, is the care you are seeking for in UK from your sponsor, mother, is it available in your home country? Yes or no? Answer is no. Follow-up question says, is the care you are seeking in UK from your sponsor affordable? Yes or no? What could this be? The care is not available, but they ask again about affordability. What are they trying to mean?
Right. So the question is the care you are seeking in the UK available
in your country?
In your country? You say no, that is why you are seeking it abroad. But they are saying, is it affordable? They are not talking about affordable in your home country. Is it affordable where you are going to get it from? And you claim you are going to get it from the UK. So can you afford it?
Yeah.
You have the means, because it's not free.
Okay.
You have the means. Has your dependent or your sponsor the means to be able to help you with that care? For example, we are talking about, let's say, adult dependent relative. If the care is coming from a care home or independent care provider, then it's going to cost you. So do you have the means? Can you afford it? That's the affordability test.
Oh, okay. So then, my friend that brought in the question, it's not about the affordability in your home country. It's affordability in the UK. Can you afford it? And then I'll ask a follow-up question, lawyer, that if they ask me about this affordability, how do I prove it? Do I have to have some money sitting in my account to prove that I'm able to afford that service here in the UK?
When they ask about affordability, it's in two parts.
Okay.
Affordability in monetary terms and affordability in kind. If you don't have the means to offer the care yourself, then you have to get it from a third party. Then you need money to get it.
Okay.
So that would be financial affordability.
All right.
Or monetary affordability. But if you are not going to buy or pay for it, but you are providing it, you have the time, the energy, the knowledge, competence, the skill to deliver that care for that person.
Okay.
What sort of person are you? So it's not just enough to say that, yes, I'm going to help my adult dependent relative who can't get the care from abroad here. But you have to show that you can do it yourself. If your work pattern is such that you are not even available, how can this person receive the care from you? So these are common sense analysis. Now, if it's about children, they ask you about who is going to care for the children. Because children must be cared for.
Yeah.
Physical care, emotional care, financial care, and everything else. But key thing, physical care. You are bringing them because you claim there's no physical care where they are. They are coming to you. But if you are not available, because you are, let's say, skilled worker migrant, you have to be working 40 hours, or that is 7.5 hours a week. Could be night, could be day, and could be rotational. So if you are not available, who is going to care for the child? Who is going to be available to physically look after the child?
You don't have to necessarily prove this at the beginning or the point of entry, or it has to be evidenced on your contract and probably the forms that you're completing?
The child's application will have a form, the consent form. In the consent form from the parent or parents, this question will come up. Accommodation and arrangement for care.
Okay.
You have to explain how you are going to meet accommodation needs and arrange care needs for the child. And again, for the child, you have to show that this is your genuine child. Again, genuineness test. Is this a genuine child? How do you prove genuine child? Relationship can be proven by birth certificate, or the recent guidance from the Home Office issued this month says that in terms of proving the relationship, you can use birth certificate insofar as it's verifiable and insofar as that country accepts that to be the birth certificate. So you can use birth certificate. The only thing is that if you can go beyond birth certificate, it's even better. Some people add DNA. So that they have the birth certificate and they have the DNA. Is DNA compulsory? No. What is compulsory? Birth certificate. Can I make it even better? Yes. If the DNA will complement the birth certificate, add DNA. It's not compulsory, and therefore you can choose to rely only on your birth certificate. And again, there's what we call family photos. The family photo will show the progression, growth progression of the child, or the developmental journey of the child. So, child was born, a baby, child is now 10 years. Over the period, there has been photos with the mother or with both parents. That will also support the evidence that this is our child or this is my child. There is a case that came to us. The lady was a nurse. She applied and she was granted. Was applying for the child, and they asked for evidence to show that it is her child, and at the same time, evidence that it's a genuine child. If you have proven it by birth certificate, what genuineness do you have to prove again? But they wanted something beyond that. So the birth certificate, when it was issued, why does the child have two birth certificates? One issued historically, handwritten, and another issued recently by digital means. Why do they have two? Why does one show that child was born? Why does one show that this was issued at this point, and the other one, the birth certificate was issued at another place? These are questions that need to be clarified. And so when the person came to us, we put all this together, asked for documentary evidence, family photos with the child, everything else, including anything that showed that there is a link between this mother and the child. I received all these documentations, made a case to the caseworker, and it was granted. So that is the point we are making, that in all circumstances, it is your case to prove that this is my child, and in addition to the birth certificate, I have other things to prove it. If the child's father is dead and you are solely responsible, you have to provide the death certificate. If the child's father is not dead, but you are proving sole responsibility, you have to show that there's no body in the life of the child to make that key decisions, what we call important decisions, to do with education of the child, to do with health care of the child, to do with religious faith or the religion that the child practices, to do with the naming of the child, even how the birth of the child was registered. So let's take this example where the child birth certificate shows that child certificate, the registration was done on, let's say, 1st of January 2023. But in your representation, you have said that you are solely responsible for the child, so sole responsibility. They ask you about the father of the child, and you said the father of the child has been out of the child's life for the past 5 years. Meanwhile, the birth certificate shows that the informant is the father. So when did you find or locate the father? so that the father went to register the child. Because the informant is different from the name of the father and the name of the mother. So there are three key things on the birth certificate: the mother, the father, and the informant. The informant is the person who is making the decision to inform the authorities to register the birth of the child. So if somebody is making that decision, then that person plays a key role in the life of the child. If it is not the mother or the father, then we are saying that somebody else plays a role. If it is the father and it is recently registered, and that father is the informant, then how do you prove that the father has been out of the child's life for that long? So these are the things that we have to be mindful of. Somebody will say that, yes, but the informant could be anybody. But informant is different from father or mother. The person going to register the child is the informant. If the person is dead, how would the person go and register the child? If the person has been out of the life of the child for a long time, and you claim that there's nobody, there's no father, or there's no mother, then how come the mother or the father is the one who informed about the registration of the birth of the child? So let's take note of that. Again, when we return, we'll touch up on a couple of things and how we can remedy them.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Right, so viewers and listeners, welcome back. As we were discussing, how do we remedy those bottlenecks? So the applicant, we have looked at what the applicant can do so that the application will be considered favorably. In terms of the job, you have to provide information, of course, that will be on the COS and therefore will be indicated on the application form. However, if you are invited to attend interview, make sure that you do attend, of course you will, and also make sure that you give them the impression that you intend, as you do, to enter the UK to work for that employer. What if you are not? Then at the point where you enter the UK, after the visa is granted, you may be asked those questions. The employer may also be asked to confirm the job. That is where you may not have control. But it is believable that if this is the employer who has given you the sponsorship and the caseworker has approached them for verification, then they will verify favorably for you. So that is done. The next thing is the fact that your immigration history. Have you been refused visa before? Please say yes if you have been refused visa before. Should it be only UK? The question will tell you whether it is only UK or any other country. It says in either UK or any other country. Sometimes you say for any country, have you ever been? So you have to say yes. If you have been refused, some people say, well, if it's not UK, I'm not going to say it. But they ask you a question and therefore give them the answer. They will ask you a follow-up questions or ask you to provide details. If you are refused for a visit, indicate that I was refused for a visit, which country, when it happened. If you want to add why it happened, you can give them a little more detail because there will be a box for you to complete. Now, if you have been refused and banned, then you don't even have to attempt the application at all because it will be banned subsequently or again this time, because once you were refused under paragraph 9.7.2 under part 9 of the immigration rules, it will trigger paragraph 9.8, which will mean that any future application will be refused, including skilled worker application. So you know yourself and you know your circumstance and you know your history. So be as honest as possible.
Well, you have been hearing from lawyer Charles Asma, who's been helping us unravel some of these things. If you have any further questions, just call him on 07947 636037. I want to take the number again, 07947 636037. There's another question that came on the platform. I think Uncle Ben has graciously answered that, but let's see if we can pick that one here from Theresa. As a skilled worker, can my dependent also switch to skilled worker for me to then switch to be dependent? That is looking at it the other way around. And let's see what answer that was brought up. I think Uncle Ben has really answered that. We go down. Yes, that one says, yes, Teresa, you need to act fast as you are likely to be in breach of the conditions of your sponsorship visa. Find a reputable sponsor and switch as soon as possible. Another question here says from Nana. This one says, I think based on what lawyer is saying, mother can ignore DNA test as a third party is required to consent for the test to spoil sole responsibility. The progressive photos, birth certificates registered earlier. I hope lawyer will answer in good time. I don't know.
I think his clarification is seeking.
Yeah, he's seeking clarification on that. So, would you do that now?
So the point we are making is this. No, we can survive without water or food. It doesn't mean they are not necessary. If it is necessary for you, go for it. If you think you don't need it, then you don't have to, because it's not compulsory. Therefore, if DNA will support your case, why not? Go for it. But if for whatever reason you think that DNA is not necessary for you, then you have to rely on the alternative evidence of showing relationship with your child, which is the child's birth certificate. And that's the only point we are making.
Okay.
We are not saying DNA shouldn't be. We are saying that DNA is not compulsory. But he added something. If you go back, So he says that DNA test as a third party is required to consent for. DNA will not come from a third party. If it's for a third party in terms of be it a mother or a father, because the main party is the child. But you are a relevant party to that DNA test because it's either proving maternity or paternity or both. And therefore, if both parents are bringing the child, they can both do DNA. If one parent is bringing the child, one parent will. It's only proving relationship. It's not proving sole responsibility. Because sole responsibility is for you to show that the other parent is not in the life of the child because that parent is either dead or absconded or abandoned. The word is abdicated responsibility for the child. If the responsibility is abdicated, then there's only one person who is responsible, making all the important decisions in the life of the child. That's where sole responsibility comes in. You don't need DNA to prove sole responsibility. You need DNA to prove relationship. That's the difference.
Well, I think at this point, because of the lack of time, we will quickly go on to look at our quiz and then we draw the curtains down. So if you just joined us, we have been looking at the reasons why the skilled worker route application may be refused and what you need to do to just prevent that. Nugget earlier on talked about no recourse to public funds. It could be taking off for students and their dependents. There's a question here. Araba and the two autistic children had limited leave with no recourse to public funds. They approached social services because they were homeless and threatened with homelessness, and Araba had insufficient income to provide private accommodation. As the immigration status prevented them from claiming benefits and accessing affordable social housing, Araba faced challenges sustaining work because of her autistic children. Now, question is, what are Araba and her two children entitled to under the law? Last week, we looked at this provision in our nugget. I'm not being tempted to go back to that, but I'm expecting that you would. So our scenario here, Araba and her two autistic children have limited leave with no recourse to public funds. They approached social services because they were homeless and threatened with homelessness. And Araba had insufficient income to provide private accommodation. As the immigration status prevented them from claiming benefits and accessing affordable social housing, she faced challenges sustaining work because of her autistic children. What are the chances of Araba and the two children to be entitled to any under the law? One, money and accommodation. Two, food and accommodation. Three, transport and food. What do you think your answers will be? I know we don't have too much time, but we'll try as much as possible to see what your options will be. Is it number one, money and accommodation? Number two, food and accommodation? Or number three, transport and food? What are Araba and her two children entitled to under the law? Maybe I'll give you a clue. Section 17 doesn't remind you of anything. Come up with your answers and let's see what you have. Araba and her two autistic children had limited leave with no recourse to public funds. They approached social services because they were homeless and threatened with homelessness, and Araba had insufficient income to provide private accommodation. So, what are the things that they will be entitled to under the law? Money and accommodation, food and accommodation, transport, and food. Let's see. I think I've got a couple of answers on there. Let's see which one. Rebecca Marcos says number two, food and accommodation. What else? Sarah Indede says number one, money and accommodation. Who else will come up with something? They kind of seem to be quite close and similar. The various things that the three situations are giving us: money and accommodation, food and accommodation. So there's a common factor here. Accommodation is kind of running through one and two, and transport and food. What else? Let's see. Another one here, Nanaya. Nanaya says number one, money and accommodation. Well, if you have money, you can buy food, don't you? Okay. Transport and food, maybe. Well, what's your answer? Let's see what you will have as answers. Tilly Duma says number one, money and accommodation. Well, for lack of time, let me quickly go to lawyer and get an explanation and see what the answers will be. I don't think anybody has chosen three. It's between one and two. Lawyer.
Thank you very much, viewers and listeners, and very good participation. Everybody has done well. So, we are looking at the duty under the law for local authorities towards children.
Mm-hmm.
And the key word is children, not parents. So, if there is a child involved and the child is in need, a child is in need, somebody who is autistic is a child in need. So there's disability and somewhat destitution. A child is in need. Now, the position of law under statute is Section 17 of the Children Act 1989. That law places duty on the local authority within that particular local authority where the child lives. So if the child lives in local authority A, then that local authority has a duty under Section 17 to ensure that the needs of that child who is in need is met.
Okay.
And the need is to be able to meet essential living. What is essential? Food, shelter, and clothing. So you need accommodation to cover the shelter. The money will cover the food and clothing. So if you pick food alone, what about the clothing aspect? So money for other things and accommodation, which is the shelter, essential living needs for the child. The local authority will provide for that child, but of course, through the parents. So the case law underpinning this, the case of Birmingham City Council versus Chloe, and this is the 2010 case. And there's also a case of H versus Secretary of State for Works and Pension, and this is a 2017 case. Both cases point to the fact that where there is a child in need, the assessment should conclude that the council or the local authority where the child lives has a duty to ensure that the needs of the child are met, the basic needs of the child. And therefore, on that basis, we say that Araba's child or children will be entitled under the law to have money and accommodation.
Well, if you look at this question, it was based on the nugget for last week when we couldn't have a chance to do that. It was about no recourse to public funds. And I remember I was asking you to look at, you remember the Section 17 thing that we talked about last week when we were dealing with the setting up of the domiciliary care. So that this question, actually, let me just put that in context and do a disclaimer, is based on the nugget we used for last week's program. So keep your fingers crossed. We will be bringing the question and the nugget for this week again on our subsequent programs. But as lawyer has explained, the options for what Araba and the two children will be entitled to again will be
So money,
and accommodation. That was that. If you would remember last week, I don't know whether my producer can get us to the nugget for last week, and we will look at the Section 17 bit of the whole thing. We can't. Yes, we have to remind you that last week we're talking about Section 17 of the Children Act, where the Section 17 was mentioned. It means you cannot get most welfare benefits, housing, or homeless help from the council. This is usually because you're based on leave to remain. You cannot get this as restrictions are placed on you. However, social services help for emergency housing, finding a private tenancy, money for rent, food, energy, and travel costs do not count as public funds. This is sometimes called Section 17. That's why I mentioned, if you do remember, we talked about something, Section 17. So that little mishap and wrong fixing there. But yes, this is what we talked about last week, and that was the quiz we intended to bring you. But next week, we will be bringing you the quiz on no recourse to public funds, where it could be removed for students and their dependents. And with that, I will come to our lawyer for a quick summary, and we'll draw the curtains down onto this program, the community and the lawyer.
Thank you very much, viewers and listeners. Today we have looked at why skilled worker visa applications get refused and what remedies we can have to prevent that. We looked at 3 categories of applications: skilled worker migrant application, skilled worker migrant dependent spouse application, skilled worker dependent child application. All these fall within appendix skilled worker provisions to the immigration rules. So there are provisions for the main applicant, provisions for the spouse or partner, and provisions for the child. All you have to remember is that if you are the main applicant, do you have the genuine intention for the job? So the COS and any question that they may ask on the application form or from the employer later as part of the verification should conclude that you intend to come and work for the employer and for the job you have applied and been selected for. Again, if you have been refused in the past, please be truthful and say yes. If you say no, it will go against you under Part 9 of the immigration rules. If you have been banned because of previous refusal, then you don't even have to try it because you will be refused automatically under paragraph 9 of Part 9 of the immigration rules, paragraph 9.8. So that is for the applicant. For the partner, we said that you have to show that there is genuine relationship and subsisting relationship. So genuine relationship is your marriage certificate, or if you have lived together for 2 years, evidence of living together for 2 years. That's the genuine relationship, marriage certificate or durable partnership evidence. Evidence of subsisting relationship, anything to show that indeed after your marriage or after living together, you continue to live together. So what do you have to prove? Anything that will link you and your partner to the same address, either in your joint name or individual names, but the same address. What can you have? Bills, energy bills, water bills, or any other utility bill. Hospital letters for attendance or for medical reviews or for whatever it is. Or anything at all that points to the fact that the two of you live at this address. Tenancy agreement, mortgage documents, land documents, that land that you own together, life insurance policy documents. All these are important, but there should be the same address and the name should be your name. So that will help you to prove. How many years should you prove? They say 2 years if you have lived together for 2 years. Otherwise, from the time you claim you started living together. So if you lived together or started living together for less than 1 year or for whatever period, that is how much you cover. But maximum is 2 years and minimum is the period that you have lived together based on what you said in your application. We are then going to look at the child. We said that for the children, the child must prove that this is their parent. So birth certificate or DNA or we said that DNA is not compulsory, but it may help you if you can add it or use it. The child must also show that if it is one parent making the application, that one parent has sole responsibility for them. Therefore, that parent, which is not in the life of the child, there should be evidence to suggest that they are no longer in the life of the child. It is one parent, the sponsor parent, who has been playing the role for them. We are also looking at showing that there is consent for the child to be relocated. When it comes to children matters, it's very sensitive. It could be child trafficking and so many other factors, and therefore they want to be sure that there's consent from the parent or the parents for the child to be relocated to another country. So where is the consent coming from? Is it from both parents or from one parent? If it's both parents, then we are saying there's no sole responsibility. If there's sole responsibility, then it should come from that parent who has sole responsibility. If it turns out that both parents have signed a consent form, then the conclusion will be that the other parent, whom is claimed not to be in the life of the child, has finally surfaced and has consented, and therefore the child can have somewhere else to live or somebody else to take care of them. Again, if the child is now coming to the UK, they are not joining you for the first time to come, but you are here and they are coming later, you have to prove that there's nobody in the life of the child to care for the child, and therefore there should be something from the person who was playing the care role for the child, and the fact that they cannot do it any longer. Letters from school, letters from hospital, letters from social welfare if the child's life is precarious, letters from police or report from police if it involves the child's, there's danger to the life of the child. All these things will support the child's application if the child is making application later to join the parent. If they are making application at the same time, family photos, as we have mentioned, and again, church letters, hospital letters, all those ones are necessary. So responsibility, very important. You have to prove it. That is what we have concluded. If you need further help, of course, you know where to go and the number to dial. Thank you for your time and enjoy the rest of the weekend.
Well, to enjoy the rest of the weekend, obviously, you have to stay well and good. But remember that our source of information and skill when it comes to legal issues, our trusted partners when it comes to legal matters, is BWF Solicitors, 214-218 Tottenham High Road, Seven Sisters, North London, N15 4NP. Call them Monday to Friday between 9:30 in the morning and 6 p.m. in the evening on 0208 493 7340 or 077 127 61884. On behalf of the production crew, we want to say thank you very much for your time. On behalf of the senior partner of BWF Solicitors, Uncle Ben, and all the other lawyers, Lawyer Charles, Lawyer Eunice, and the rest of the family headed by Auntie Cynthia, we want to say thank you very much for patronizing the services of BWF Solicitors. If you have any questions, contact us and we will be happy and ready to address them. My name is Riku Sifrimpon. My studio producer has been Professor Ade and supported by Sheila Ankra and Padmo. Good evening.